Hello everyone, it's May 24th, 2024 at the time of this recording. This is Gerry Gagnon and Michele Tittler from the political organization in Canada, Endracebasedlaw. Law. And Gerry is going to very succinctly take us through why to end race-based law. So there you go, Gerry, hit it.
Okay. Well, just to show that we're not making this stuff up off the top of our heads, the government of Canada actually agreed with us and where we're now coming from 55 years ago to this month. And it was called the Statement of the Government of Canada on Indian Policy. Now it's known publicly as the White Paper, the infamous White Paper of 1969. Now, when we started our websites 9 years ago, one of the first posts we put up was something. I went through the white paper and I edited and paraphrased it. I took out the government propaganda and patting themselves on the back, and left the essential elements of the paper intact. So I'm reading what I'm reading to you now is actually the government's own words. The 1969 government of Pierre Elliott Trudeau and Jean Chrétien as Minister of Indian Affairs. Now, to put it in context, the government, once the Aboriginal elites reacted poorly to this, they backpedaled and retreated from what they should have done and what would have avoided 55 years of things getting worse on the Aboriginal file. So if I may, this is on our .com site. It is at the top of the page, and it's entitled, Why End Race-Based Law? Quote, Canadians believe in equality, that all men and women have equal rights. We have determined that all shall be treated fairly, and no one shall be shut out of Canadian life because of his or her race. Government of Canada speaking here. Only a policy based on this belief can enable Canadians of Aboriginal heritage to realize their needs and aspirations. Native Aboriginal relations with other Canadians began with special treatment by government and society, and special treatment has been the rule since Europeans first settled in Canada. Special treatment has made of the Aboriginals a community disadvantaged and apart. Obviously, the course of history must be changed. Government of Canada. The changes proposed recognize the simple reality that the separate legal status of Aboriginals and the policies which have flowed from it have kept the Aboriginal people apart from and behind other Canadians. The treatment resulting from their different status has often been worse, sometimes equal, and occasionally better than that accorded to their fellow citizens. What matters is that it has been different. We can no longer perpetuate the separation of Canadians. Now is the time to change. The government should be prepared to take the following steps to create this framework. Propose to Parliament that the Indian Act be repealed and take such legislative steps as may be necessary to enable Indians to control Indian reserve lands and to acquire title to them. Start the constitutional amendment procedures necessary to remove the specific references to Indians in the Constitution. Propose to the governments of the provinces that they take over the same responsibility for Canadian Aboriginals that they have for other citizens in their provinces. The takeover would be accompanied by the transfer to the provinces of funds normally provided for Aboriginal programs, augmented as may be necessary. Wind up that part of the federal government which deals with Indian affairs. The residual responsibilities of the federal government for programs in the field of Aboriginal affairs would be transferred to other appropriate federal departments. Canada cannot seek the just society and keep discriminatory legislation on its statute books. The ultimate aim of removing the special references to Indians from the Constitution may take some time, 55 years later, but it is a goal to be kept constantly in view. In the meantime, barriers created by special legislation can generally be struck down. And they go on and refer to including Section 91, which enabled the Indian Act, and other federal statutes, Section 718 of the Criminal Code, the Gladue Code, which we'll do in a separate broadcast, also affect Aboriginal policies. Removal of this and other references in the Constitution, including now Sections 25 and 35 of the Constitution Act 1982. Removal is necessary to end the legal distinction between Aboriginals and other Canadians. In the short term, repeal of the Indian Act and enactment of transitional legislation to ensure the orderly management of Aboriginal land would do much to mitigate the problem. Services must come through the same channels and from the same government agencies for all Canadians. This is an undeniable part of equality. It has been shown many times that separation of people follows from separate services. There can be no argument about the principle of common services. It is right. Government of Canada. Now they have all kinds of separated services. It cannot be accepted now that Aboriginals should be constitutionally excluded from the right to be treated within their province as full and equal citizens, with all the responsibilities and all the privileges that this might entail. It is in the provincial sphere where social remedies are structured and applied, and the Aboriginal people, by and large, have been non-participating members of provincial society. Canadians receive a wide range of services through provincial and local governments, but the Aboriginal people in their communities are mostly outside that framework. It is no longer acceptable that the Aboriginal people should be outside and apart. The government must ensure that services are available on an equitable basis, except for temporary differentiation based on need. Services ought not to flow from separate agencies established to serve particular groups, especially not to groups that are identified ethnically. Now, if only our current federal government would read this. Therefore, the traditional method of providing separate services to Canadian Aboriginals must be ended. All Aboriginals should have access to all programs and services of all levels of government equally with other Canadians. The terms and effects of the treaties between the Canadian Aboriginal people and the government are widely misunderstood. A plain reading of the words used in the treaties, Supreme Court take note. A plain reading of the words used in the treaties reveals the limited and minimal promises which were included in them. The significance of the treaties in meeting the economic, educational, health, and welfare needs of the Aboriginal people has always been limited and will continue to decline. The services that have been provided go far beyond what could have been foreseen by those who signed the treaties. A policy can achieve no more than is desired by the people it is intended to serve. The essential role of a new approach is that it acknowledges the truth by recognizing the central and essential role of the Aboriginal people in solving their own problems. It will provide for the first time a non-discriminatory framework within which, in an atmosphere of freedom, the Aboriginal people could, with other Canadians, work out their own destiny. Government policies must lead to the full, free, and non-discriminatory participation of the Aboriginal people in Canadian society. Such a goal requires a break with the past, not an expansion of it as is currently happening. It requires that the Aboriginal people's role of dependence be replaced by a role of equal status, opportunity, and responsibility, a role they can share with all other Canadians. We must not perpetuate policies which carry with them the seeds of disharmony and disunity, policies which prevent Canadians from fulfilling themselves and contributing to their society. Governments can set examples, but they cannot change the hearts of men. Canadians stand at the crossroads. For Canadian society, the issue is whether a growing element, the fastest growing element of its population, will become full participants, contributing in a positive way to the general well-being, or whether, conversely, the present social and economic gap will lead to their increasing frustration and isolation, a threat to the general well-being of society. For the Aboriginal people, the only road that existed since Confederation and before was the road of different status, a road which has led to a blind alley of deprivation and frustration. This road, because it is a separate road, cannot lead to full participation, to equality in practice as well as in theory. This belief is the basis for our determination to open the doors of opportunity to all Canadians, to remove the barriers which impede the development of people, of regions, and of the country. Unquote.
Well, I have not heard that since we put it up many years ago.
And I don't have anything to add to that at this point.
That was really great. That was really, really great. Thank you. And so that's where we're at. That's what we're doing. And the news went crazy over this.
I think it, in some sense, answers the two questions we were asked from the very beginning, is what race-based law? What are you talking about? And why would you end it? Don't the Aboriginals want it, so why can't they have what they want?
Well, here's the thing. We're not going to talk much longer here, but they complain about all of the things that we too can notice and see, and yet at the same time they want to keep all of this. They want to keep it all because it means money. It's extortion.
I hope the rest of you will have heard this in the same spirit that I first took it in, which I really don't have anything to add to what was set there. It covered the bases that we try to cover. It showed philosophically where we're coming from.
Yep.
And for having this set of beliefs and purpose, we've been called racist, white supremacist, and on and on and on. Please go back and listen to this once again with that in mind, and see where there's anything in there that even remotely connects.
This says end race-based law, not end natives. Okay, this is about lawyers and lobbyists and politicians and
that's going to be
quagmires of court cases.
Be a whole other broadcast, which is the industry itself.
Yes, the industry
the billion-dollar industry.
So stay tuned for more. Good job, Jer. Good job.
So.
Thank you for tuning in, everyone.
Thank you for listening and
you.
watching.
We love you, Canada. And race-based.
Good luck to us all.
And race-based law, unity for Canada.